Hello, and thank you for joining me on this installment of the RICO Report, where we're going to talk about the RICO conduct element. My name is Cal Stein, and I'm a partner in the white-collar and litigation practice groups at Troutman Pepper. I represent clients in white-collar criminal and government investigation matters, as well as in complex civil lawsuits and in RICO litigation. I am very pleased to have my partner Joanna Klein here with me today to talk about the four subsections of RICO conduct that are found in 18 U.S.C. Section 1962. Joanna is a commercial litigation partner at a Troutman Pepper's Wilmington office. Joanna, it's wonderful to have you here today. Why don't you tell us a little bit more about yourself?
Thanks, Cal. Great to be here. I am the office managing partner of our Delaware office. I focus on complex commercial litigation on the civil side. I'm not a criminal lawyer, but we do a fair amount of civil RICO, securities, corporate governance, and basically anything that happens in the Delaware Court of Chancery.
Terrific. Well, we really appreciate you being here today to talk about the RICO conduct element. And let's jump right into that. So the RICO statute contains a subsection aptly titled Prohibited Activities. And as I said, that's found at 18 U.S.C. Section 1962. That section actually contains four subsections labeled sub A through sub D that enumerate the specific conduct that the RICO statute prohibits. And today, for the purposes of this podcast, we're going to actually follow the RICO statute's organization, and we're going to discuss in detail each of these four types of conduct individually. For context, though, the four types of prohibited conduct are investing the proceeds from a pattern of racketeering activity in an enterprise, acquiring or maintaining an interest in an enterprise through a pattern of racketeering activity, conducting the affairs of an enterprise through a pattern of racketeering activity, and then the final section is conspiring to do any of those things. And before we get into our discussion of each of those four subsections of the RICO conduct, I want to take a moment to address briefly some of the other RICO concepts that we're going to be discussing today, but which are not going to be the focus of this episode. They may be the focus of later ones, but not today. And specifically, I want to talk about the RICO person versus the RICO enterprise. Joanna, you have some experience with these concepts. Can you briefly take us through them so listeners can follow along with our discussion today?
I mean, as you sort of hinted at, the person-enterprise distinction could be the subject of a whole other podcast onto itself. So today we're just looking at the big picture, really, which is that RICO defines person broadly. So that can be any individual or entity capable of holding an interest in property. And then when you look at enterprise, RICO likewise defines enterprise broadly. And we might think sort of in everyday parlance of the quintessential RICO enterprise as an illegitimate enterprise, like the mafia. But it can just as easily be a legitimate enterprise. And it gets tricky as it can be an individual or an entity or a group of associated individuals or entities. And trying to distinguish, once you get through the weeds of all of this, between the person and the enterprise can get confusing. It's not our mission today to try to figure that all out, but the concept is important to our discussion today because under three of the four subsections we're discussing, A, B, and D, the RICO person and the enterprise can be the same thing, but importantly, under subsection C, which I think we'll find is where the action is, those two concepts have to be distinct.
So you're quite right, Joanna. This could be the subject of its own standalone podcast and may one day be the subject of such a podcast. But for today, that's a helpful distinction to understand, and I appreciate the summary. So with that, let's turn to the first subsection, which is section 1962A, which involves the investment of racketeering proceeds. And generally, the conduct that is prohibited by this section is something of an anomaly in the RICO world, because the essence of a violation under 1962A is not the commission of the actual racketeering acts, but rather it's the investment of the income derived from those racketeering acts. The elements of a 1962 violation are, number one, a person derived income from racketeering activity. Number two, that person then used or invested that income Number 3, to acquire, establish, or operate a RICO enterprise. And when we were preparing for this podcast, Joanna, we were talking about just how atypical Section 1962A RICO claims are. And I just spoke about how this subsection is a bit unique because the critical conduct is not the racketeering activity, but rather what the perpetrator of those racketeering acts does with the proceeds. Do you think that kind of unique setup is one of the reasons that we as litigators don't really come across 1962A claims all that frequently?
I think that's right, Cal. One of the big challenges of a 1962A claim, and one of the reasons they're rare, is that a plaintiff must trace its injuries to the investment of the proceeds, as you say. So, for example, in the context of the sale of a stock in a business, if a party purchases stock with income it derived from racketeering activity like wire fraud or securities fraud, that would be the requisite investment for 1962A purposes. What we're really talking about here is money laundering, and it's not all that common.
I think that's exactly right. Another paradigm we sometimes see for 1962A purposes is when a party makes an investment with a loan that he or she obtained through racketeering acts, usually wire fraud, but it could be a couple of other things. But notwithstanding these examples, even pleading, much less actually proving a 1962A claim and that one has actually been injured by virtue of the investment of ill-gotten proceeds can be very difficult, which is one of the reasons, as you noted, we don't see them all that often. Okay, so as we move through the various subsections here, and we will get to some that we see more frequently, and therefore there's a little bit more law and meaty legal issues for us to talk about, let's move to the next subsection, which is 1962B, which is acquiring or maintaining an interest in an enterprise. And the conduct that's prohibited by 1962B is actually somewhat similar to the conduct that's prohibited by 1962A. The major difference being that 1962B prohibits the acquisition or control of an enterprise through racketeering acts rather than through the investment of income derived from the racketeering acts like we saw in 1962A. There are two elements for a 1962B claim. The first is that a person committed racketeering acts, and the second is that the person did so for the purpose of acquiring or maintaining an interest in or control over a RICO enterprise. And when analyzing a 1962B claim, the key for me is that there has to be a connection or a nexus between the racketeering activity and the acquisition of the interest in or the control over the enterprise. I note that the critical component is not the racketeering activity itself, it's the acquisition of control. The injuries under a 1962B claim must also stem from the acquisition of control. It is not sufficient that they come from the racketeering acts themselves. That's a nuance and a distinction that's actually quite important. And some courts have even held that the damages have to be different. The damages that arise from the acquisition of control have to be different than the damages arising from the racketeering acts themselves. That's what I find interesting about these claims. But how about you, Joanna? What do you find most interesting or challenging about 1962B claims?
Yeah, and again, these are few and far between, so it's not like these get a lot of airtime. But we can look at the other piece of the equation you mentioned for a subsection B claim, which is what constitutes an interest or a control over an enterprise. And in essence, to satisfy that requirement, the person must have played some significant role in the management of the enterprise, though establishing that he or she had complete control is not necessary. So as you can see, just by the articulation of that standard, it's a highly specific fact determination, which can be quite frustrating for the RICO defense bar because it makes for a hard argument to assert at the motion to dismiss stage. So it gets to be expensive.
Yeah, unfortunately, I think you and I have both had that experience in various RICO claims. Okay, well, as you said, subsection B, like subsection A, they're out there, but there aren't that many claims that are brought under those subsections. The vast majority, which you alluded to, Joanna, are brought under the next section, which is 1962C, which is conducting the affairs of an enterprise through racketeering activity. As noted, 1962C is by a wide margin the most commonly used RICO subsection, and that applies to both criminal prosecutions and civil actions. On its face, you might think that a subsection C appears to be less demanding than some of the other RICO sections. And while the language may convey that, the courts have not always interpreted it as broadly as the others, perhaps as a function of the frequency with which it is used in comparison to the others. The elements of a 1962C claim are as follows. First, a person who is employed by or associated with a RICO enterprise. Second, conducts or participates in the conduct of that enterprise's affairs. Through 3, a pattern of racketeering activity. And again, because of the frequency with which these types of claims are brought under this subsection, there's actually quite a bit of case law out there interpreting these elements. So let's take a moment and really unpack some of this in a way that we weren't able to do with the other two. Joanna, earlier in the podcast, you talked about the RICO person versus the RICO enterprise distinction, and you noted that those rules were a little bit different for 1962 claims. Can you elaborate on that a little bit?
Yeah, sure. And again, a lot of ink has been spilled on this person enterprise distinction. So we're just going to hit it at a high level. But generally speaking, it goes back to the text of the statute. And because under subsection C, the person must be employed by or associated with the enterprise, the courts say that those two things must be distinct. That means that a defendant to a 1962C claim cannot be both the person and the enterprise. Now, courts do recognize that a person may be a member of the enterprise, but it can't be the same thing. So when that sort of gets confusing, and when it often comes up, is we see it a lot in the context of whether a corporation is distinct from the individuals who operate the corporation. So, for example, there was a famous Supreme Court case called Cedric Kushner Promotions versus King, and by King I mean Don King, where the Supreme Court held that even where a corporation has a single stockholder, the corporation itself and the stockholder are distinct for RICO purposes, and the individual human can face liability in terms of being a person under the statute. But compare that against some other cases when a plaintiff seeks to hold a corporation liable as a person in those circumstances. Courts have rejected the liability there because in that case, seeking to hold the corporation liable would essentially be saying the corporation is operating itself, and that's not sufficient. So again, it's very nuanced, but the big picture takeaway is you have to pay attention to whether the person and the enterprise are distinct, and it gets super tricky in the context of corporations and their directors.
I have to say, I love that Don King case. We're all familiar with it, but I do love it. Another oft-litigated question under subsection C of 1962 is what exactly constitutes conducting or participating in an enterprise's affairs? The U.S. Supreme Court has actually weighed in on this and imposed a managerial gloss on this requirement, basically saying that only those who have the ability to direct the operations or management of the enterprise can satisfy this element. And the case here is another famous one. It's Reeves v. Ernst & Young. And here's what the Supreme Court said in that case. In order to participate directly or indirectly in the conduct of such enterprises' affairs, one must have some part in directing those affairs. What is really interesting to me about this case is I think the Supreme Court thought that it was announcing a rule that would be kind of easy for the lower courts to apply, but as is often the case, this managerial test has been anything but easy, at least in my experience. How's it been for you, Joanna?
We have a colleague in our Philadelphia office, and every time I mention to him that I'm doing a podcast or giving a CLE, he always says, let me know what the question is. And then he interrupts me and he says, I know it doesn't matter what the question is because the answer is it depends. And he's not entirely wrong, I have to say. So with this question of the managerial test, one reason that it's not susceptible to a simple insider versus outsider distinction is because the case law is not such that all individuals inside the enterprise with formal positions necessarily satisfy it, while all those outside do not. So let's break that down a bit. So let's look at insiders. While the majority of individuals who do conduct the affairs of an enterprise qualify as insiders, but being an insider is not in and of itself sufficient. That's not enough to get you there. Courts have been pretty clear that merely performing services for an enterprise does not equate to conducting its affairs, even if the person performs services with knowledge of illicit activity. In other words, even for insiders, there's no per se test, not even for people whose title places them in upper management. To satisfy the requirement, a plaintiff must still establish the person's managerial role within the enterprise. So that's insiders. And now let's take a look at outsiders. The same is true, really, although fewer outsiders are going to satisfy the managerial test for obvious reasons. But there's no per se rule that applies. And the Supreme Court made this clear in the Reeves case. It held that status as an outsider is not dispositive, while complete outsiders, which it defined as those who manage their own affairs as opposed to the affairs of the enterprise, do not qualify. Other outsiders who do manage the affairs of the enterprise will qualify. And as the law has developed, the rule on outsiders has essentially become that those who go beyond the routine rendition of professional services and become so intertwined with the enterprise may be said to conduct its affairs for 1962C purposes. Again, we're talking again about a fact-intensive inquiry that drives the defense bar crazy.
This one does drive me crazy because there's so many times you want to argue it on motion to dismiss, but you can't quite get there because the facts aren't developed enough yet. So as we said, that's section 1962C in a nutshell. That's the most common RICO subsection where claims are brought. But we'd be remiss if we didn't address the fourth section as well, which as a white-collar criminal defense attorney is a bit near and dear to my heart, which is 1962D, the conspiracy to commit a RICO violation subsection. 1962D is something of an outlier from the other RICO subsections, and it's also an outlier from what we often think of as traditional conspiracy law. And the reason for this is that the crux of a 1962D RICO conspiracy claim is the agreement amongst the co-conspirators to commit the conduct that violates one of the three subsections that we just talked about. And 1962D is really concerned only with that agreement, not whether the violation was actually completed. There are three elements to a 1962D claim. The first is that two or more people agree. Number two is they agree to invest in. That's a 1962A claim. Acquire. That's a 1962B claim. Or conduct the affairs of, that's a 1962C claim, a RICO enterprise. And then third, in a manner that violates one of those three subsections that I just mentioned. And, I always struggle with this one, Joanna, because as I just mentioned, I am a white-collar criminal lawyer. And when I hear conspiracy, I think about all the rules that apply in the criminal context. But a RICO conspiracy is really quite different.
Yeah, agreed. So even in the civil context, when you think of RICO, when you think of conspiracy, you think of the agreement and an act in furtherance of the agreement. That is not the same ballgame when you're in the RICO context. The RICO conspiracy is complete upon the agreement. And so the test for establishing an agreement requires a two-part showing. Number one, that the defendant agreed to facilitate the operation of an enterprise through a pattern of racketeering activity. And number two, that the defendant agreed that someone, though interestingly not necessarily the defendant him or herself, would commit at least two predicate acts. So with respect to that second prong, that means there is no requirement in subsection D claims that the defendant himself commit the pattern of racketeering activity. Under 1962D, it is enough that a person agreed with another person and intended to further an endeavor that would, if it were completed, satisfy the elements of one of the other RICO sections.
Yeah, it's such a departure from what we typically think about in terms of conspiracy claims that I always find it really, really interesting. The other piece of a 1962D RICO conspiracy claim that I find interesting is how it interacts with other claims that are brought under the other RICO subsections that we've discussed, which they often are. Have you found that, Joanna?
Yeah, so they often are, and the question then becomes, do they have to be? So the question then becomes whether a viable claim for A, B, or C is necessary for someone to pursue a claim under subsection D. And the courts are divided on the issue. Some say that a plaintiff can bring a conspiracy claim even if other claims under A, B, and C are dismissed, so long as they can prove the elements of 1962D standing alone. Others have held that a subsection D claim cannot stand on its own. And some have even dismissed the subsection D conspiracy claim because the plaintiff failed to properly plead the underlying A, B, or C claim. So it's important to know what the particular jurisdiction you're dealing with says on the issue.
Yeah, that's a situation that as defense attorneys, I think we've all been in, where we're writing our motion to dismiss or our summary judgment brief, and we're saying, well, the conspiracy claim fails for all the same reasons we just wrote because all the underlying claims fail as well. Maybe not the case for a RICO conspiracy claim, depending on the jurisdiction that you're in. Well, Joanna, we're about out of time here today, so I do want to bring this discussion to a conclusion. I really want to thank you for joining me on this podcast. I also want to thank everyone for listening. I hope that you will all join us for our next regularly scheduled installment, in which we'll be discussing the RICO Enterprise, which we talked a little bit about today. If you have any thoughts or any comments about this series, I invite you to contact me directly at callan.stein@troutman.com. If you have any thoughts or comments about this episode, you can also contact Joanna directly at joanna.klein, that's C-L-I-N-E, @troutman.com. You can subscribe and listen to other Troutman Pepper podcasts wherever you listen to podcasts, including on Apple, Google, and Spotify. Thank you for listening, and stay safe.
Copyright Troutman Pepper Hamilton Sanders, LLP. These recorded materials are designed for educational purposes only. This podcast is not legal advice and does not create an attorney-client relationship. The views and opinions expressed in this podcast are solely those of the individual participants. Troutman Pepper does not make any representations or warranties, express or implied, regarding the contents of this podcast. Information on previous case results does not guarantee a similar future result. Users of this podcast may save and use the podcast only for personal or other non-commercial educational purposes. No other use, including, without limitation, reproduction, retransmission, or editing of this podcast may be made without the prior written permission of Troutman Pepper. If you have any questions, please contact us at troutman.com.